In Australia, individuals are allowed to reproduce or reappropriate copyrighted material for research or study pursuant to Section 40 of the Copyright Act. This precedent and its limitations were explored in common law in the case of Garis and Neville Jeffris Piddler Proprietary Limited. But before we jump straight in, let's have a look at the background of fair dealings and the research and study exception. The 1968 Copyright Act provides protections to creators over their creative works for a whopping 70 years after the death of the author. Now this may sound like a long time, and frankly, that's because it is. For example, let's say you're a huge Star Wars fan. If George Lucas died today, then Star Wars wouldn't become public domain until the year 2088. Now I can understand your disappointment because this is an extremely long time to wait for that reboot you've probably been planning to make. But we have to provide these protections so that creators keep creating. However, as illustrated, copyright can be extremely long and quite limiting, so we introduced exceptions that allow copyrighted material to be used under certain circumstances within these enormous lifetimes. Fair dealings exceptions allow us to appropriate copyrighted material to make criticisms, to report on the news, make parodies, and in the case of Garis and Jeffris, to use them for research and study. In Garis and Jeffris, the main contention was whether or not servicing newspaper clippings as a third-party research body was a breach of copyright. Don't panic, it gets more exciting. Maybe. Jeffris claimed that under the research and study exception in fair dealings, their company was allowed to reproduce the work as a third party. This is an issue as under the Copyright Act, there are certain considerations when looking at the research and study exception. These considerations are unique to the research and study exception, and most relevant to the court was the purpose and character of Jeffris's dealings. Of all things, the court turned to an ordinary dictionary to determine whether Jeffris was acting in the course of research and study or whether their intentions actually differed. Now I won't read out the whole thing, but it is an important definition to look at as it determined whether or not a third party acting in this way would be seen as researching or studying. It's definitely worth taking a look at. Although Jeffris's clients were most likely engaging in research, there was no evidence to suggest that Jeffris was applying the information in anything other than a commercial fashion. Jeffris was merely engaging in a for-profit research service with no real intention of actually applying the research themselves. Justice Beaumont recognized that Jeffris's main intention was to provide the research service for a commercial purpose. Thus it was decided that Jeffris's use of the copyrighted material was not protected under research and study exceptions. Further, it was reached that a third party couldn't exercise the research and study exception on behalf of another person at all. It must be for the person's own research or study. This was a narrow interpretation. However, where Australia has ruled for narrow interpretations, international cases have adopted broader ones. This is in direct contrast to Canada, which has held the opposite. The Law Society of Canada was providing a custom photocopy service in which legal materials were provided. Wow, maybe these cases don't get any better. Anyway, CCH was a publisher within the library and took the position that the photocopying breached copyright laws. The Supreme Court recognized a multifaceted test, one very similar to our own, to determine whether the photocopying service breached copyright laws. Canadian courts recognized that in applying this test, it was important to remember that in interpreting research, the court stated that it must be given a large and a liberal interpretation in order to ensure that users' rights aren't unduly constrained. The Supreme Court of Canada decided that they would allow an organization to make copies on behalf of other people in reliance of the research and study exception. Garis and Jeffris is a case that students should keep on hand as it illustrates the exceptions in which copyright material can be used for research and study. But also, the case is an excellent example of how Australian courts can sometimes have a narrower approach to certain elements of intellectual property law.
Created using Powtoon.